All right. Thank you all for coming on such a beautiful day. I'm John Coates. Probably know, I don't know, 10 or 20% of you, by face at least, so that's good. I've been given the unfortunate task of following Charles Fried and Trevor Potter in this series, neither of whom has ever said an unclear or uninteresting word, as far as I can tell. And worse, I'm going to have to introduce corporations into the series, which all by itself is a threatening fact. And had you asked me 10 years ago whether a corporate lawyer would have anything meaningful to add to an election law series, I wouldn't have thought yes. I would have thought no. And that's because, as you probably know, corporations traditionally have not had a role in our election system in a direct way. In fact, they still cannot give money directly to candidates. But because of Citizens United, except I can't get this to work. There we go. We now, in the corporate law side of the faculty, are being pulled in increasingly to constitutional law debates, partly because the Supreme Court, when it does write about corporations, gets it wrong. Pretty badly wrong from a corporate lawyer's perspective. So these are three quotes from the opinion, and only the first one is true. Microsoft keeps changing my numbers on me. The second one should be numbered 2. And I'm going to hopefully convince you that the second and third really don't have much truth to them, and yet there they are in the opinion and functioning, importantly functioning in the analysis of the court. The decision also, as you probably know, did that. So this is just increase in use of registered lobbyists, the same pattern of use of PACs. Now, what we don't know is what we don't know, which is how much corporate money is being directly funneled into elections other than through PACs and other than through lobbyists. You might not think of lobbyists as a channel for election spending, but in fact, lobbyists, one of their main roles other than lobbying is to raise money for candidates and then arrange for the donations to be made. What we don't know is the dark money, the money being channeled to 501c4s and C6s and trade groups. And you heard, if those of you who were here for the last one, Trevor Potter, I thought pretty devastatingly described both the lack of understanding, the lack of awareness, lack of information, lack of enforcement by the Federal Election Commission about all of that and the IRS. And so what we don't really know is just how bad things are. But what I want to do, instead of really focusing on the specifics of the election impact of Citizens United, I'm going to take a couple steps back and ask questions about the analysis in the case. And then I hope to convince you that there's some problems that are both broader than election law, but also intersecting with and providing a foundation for the problems of corporations and elections. And then hopefully come up with some suggested options, and if I have time, actually analyze whether the options are constitutional. So quick history here. I've asked this of some of you in other settings. Anybody know? What's the answer to that? When did corporations first get protected? And I want to set this up, just emphasize the court says there's 2 lines of precedent here that we are confronted with, hence we can go the way we want to go. So there's a suggestion there that there's a line, and a line the last time I checked with my daughter's geometry class consists of 2 points to make a line. So I think we need 2 cases. So the question is, what are we talking about when the court's looking back to this line of cases? And the answer is, anybody want to take a stab? 1978 is the answer. That's the first time in the history of the Republic that the Supreme Court recognized a right to political speech on behalf of a corporation. And it's also the only time prior to Citizens United, once. That's not twice, that's just once. So whatever line of cases is, I'm not sure the court was thinking carefully when it wrote it. Now, it is true that prior to that, there was Virginia Pharmacy, and it's also true that prior to that, there were a bunch of cases in the 50s and 60s in which the media business, basically, companies in the business of expression, brought cases, companies in the business of expression brought cases under the First Amendment, but they all of them actually had individuals also involved. New York Times v. Sullivan, the op-ed writers, go down the list. Each of those cases had somebody other than the corporation who could have easily stood for the First Amendment bearer of rights in those cases. So really the first time the court expanded beyond expressive businesses with individuals involved was in Bellotti. Virginia Pharmacy in 1976 actually didn't involve a business. It involved a consumer group seeking to get information about businesses, but it wasn't actually a corporation involved in the case. So that's just the main point, right? So just to be clear, when the court says it's recognized this, they're talking about Bellotti. When they're talking about this line of precedent, they're talking about Bellotti. And when they're quoting in this third one, through that shareholders can protect themselves through the mechanism of corporate democracy, they're quoting Powell in Bellotti. So this all kind of hinges a lot on this one case. And now, second historical point. When did the US become the world's economic power? Any business historians? Rough stab. Yep. Post-World War II. Anybody want to go? Different answer? Post-World War I, different answer. Post-Spanish-American War, what's that war? 1900, certainly by 1900. So here's a chart from The Economist that shows the world's economies in the US is already the largest in 1900, and it's remained that way ever since. So what's the point of that? Well, we didn't need the First Amendment to protect American business to get to be the world's largest power. Moreover, during that history, we also had an enormous amount of regulation of corporate business speech. At the founding, all of the first-year contracts, torts, other classes that you've had, all those doctrines, they were in place at the founding. If you think carefully about each of those courses, you should recognize that the courts imposed penalties on companies for the way they spoke. Fraud, just to take the most obvious one, on which most modern disclosure regulation is founded. And nobody even thought twice about whether that was consistent with the Constitution. Here's what the founding generation thought about the idea of corporations as rights bearers. The Chief Justice Marshall, who was there at the founding and then was the Chief Justice, just sort of dismisses it quickly without a whole lot of deep analysis. Of course not. That's not what we had in mind. And it's not as if we didn't have things equivalent to modern corporations back then. The Bank of the United States was the central first major political battle of the United States. It was on his mind when he wrote these cases. It's not as if he didn't understand what he was saying. Moreover, remember, it's 1978 when we first get the idea of corporations as bearers of First Amendment rights outside the media business. And during the pre-1978 20th century, we get layer upon layer upon layer upon layer of regulation. You learn about it in other classes. And partly I make the point here just, this is all in place before the court intervenes, but also to point out what's at stake. Because, as I'll show you in a few more minutes, corporations and their lawyers and their litigators are now steadily going around and attacking each one of these under the First Amendment. And they are winning some real successes sometimes in a very unpredictable, I would say, fashion, something I'll come back to. So whatever you've learned about in food and drug law, FCC, if you care about internet neutrality, if you care about the SEC, if you care about, go down the list, consumer disclosure more generally. All of it is disclosure regulation vulnerable under the First Amendment because of the line of cases that started in 1978. So here's a more specific depiction of this. This is business involvement in First Amendment cases in reported Supreme Court decisions. And you can see there are 4 periods. There's a period where there's none. And then there's the period that I'm describing as the media period, when it's all of those are newspapers, publishers, film companies, whose business is to express. And then you have this giant ramp up. And for those of you who haven't seen me do this already, anybody want to take a shot at what else besides the increase coincides with those 2 lines? Anybody? Any Supreme Court historians to give you a hint? Roughly 1972 to 1987. You might think Roe v. Wade, but that's not it. So here's the answer. Justice Powell wrote a memo before he went on the bench. He was a corporate lawyer. He's one of the very few and the only modern corporate lawyer to go on the Supreme Court. He wrote a memo as a hired consultant for the Chamber of Commerce, which I encourage all of you to go read. It's available if you Google it. It's an amazing piece of legal reform planning. So whatever your political perspectives, it's a good model for how to think about changing the world through the court system, because that's exactly what he said they, meaning the chamber, ought to do. They ought to use the courts to change the nature of business and the economy and society and politics. Now, when he got nominated very shortly after this by Nixon, probably partly because of the memo, and it didn't get leaked before his confirmation hearing, so he was confirmed. Had it been leaked, I'm fairly sure it would have been a fairly controversial confirmation. And I can say that with some confidence because, of course, when Roberts was confirmed, he had to say things like this, right, which is a little different than that. In fact, there's almost no overlap between those visions of what judges should be doing. So we come back to our chart here, and that's when Powell's on the court. Now, history's complicated. He's not the only actor. He's not the only person causing this to happen. But I just will assert he's a major actor in both setting business up to pursue this as an avenue for legal change and then helping implement it as a member of the court, not only as a vote, but as an author of the Bellotti opinion, among others. So now, if this were all that I was showing you, this should be troubling enough from a neutral legal perspective. But win rates for businesses also have gone up dramatically since 1978. So they're now basically in line with individuals. And at the appellate court level, which is probably more important as a practical matter for the determination of law than the Supreme Court, since the Supreme Court only has a tiny, tiny little docket, the number of cases citing to Central Hudson, which is the leading case implementing the First Amendment for business speech, commercial speech, is, as you can say, just going up, right? And in fact, if you did the first half of 2015, it would be almost as big as 2014 as an entirety. And so I'm fairly sure we're going to have more than the 2014 by the end of the year. So this is appellate level cases across a whole range of different disciplines. And this should be troubling. This should be troubling even to the Supreme Court, even to the part of the Supreme Court that thinks in principle the law here is a good idea. They don't like having their judicial system clogged with ever more cases under a particular doctrinal line, right? And in fact, this is a very unusual pattern. This is 20, 30, almost 30 years, 25 years of growth. You rarely see this. If you take, for example, at Central Hudson again, the one I just had up, if you take exclusionary rule, sort of the invented way to protect civil liberties by the Supreme Court, in the appellate courts, you had this big jump up as the courts wrestled with what exactly it meant, and then you had a predictable falling off over the next ensuing period. Likewise, Roe v. Wade, same basic pattern. So this pattern down here is hard to find. And I'll submit it has a lot to do with who it is that's bringing these cases. That is, large, well-funded businesses whose entire business strategies depend increasingly and sadly on litigation strategies, as opposed to individuals who happen to get caught up in the justice system or individuals who seek to confront particular political reactions to privacy rights or other kinds of civil liberties. So that's the history. Policy, let me say some things about why all this is bad. So 1 in 6 of the S&P 500 company CEOs whose companies were politically active went on to higher political office, not advisory boards and decorative things that you put on your resume, but ambassadors to England, senators, US Treasury secretaries, SEC commissioners. One of them is running, at least one is running for office. I haven't counted, actually. I know Fiorina would be in this group, and there are probably others running for president. So Now, why is that troubling? Well, because in a public company context, for those of you who had corporate law, we worry about conflicts of interest. We don't, however, typically treat conflict of interest of the kind where the CEO diverts resources to uses that are personally valuable, but that don't directly involve a financial conflict. So this is not CEO personally getting money from the company. This is the CEO using corporate shareholder money to advance in politics by giving money out to favored candidates who then form a network of reciprocal benefits which allow the CEO to go on to get the kind of office that they get. Now, in fairness, CEOs are smart, hardworking people, and some of them probably would go into higher office anyway, but the difference between the political activity of the company they run is pretty stark, and there's no way to control that away through all the regressions you want. Here's another fact. CEOs use their own jets for personal use, and when they do, they have to report that, and the ones whose companies are politically active, who are more likely to go into political office, are more likely to be using it for their own personal purposes. Now, you know, I like a personal jet. I'm happy to fly them. I flew in a couple when I was in practice. They're fun. I totally get why they use the corporate jet for their personal use to fly their dog around or whatever. And a famous example of the RJR chairman who used to, G. Shepard was on the list when the boards, when the pilot had to list who was on board, G. Shepard. But when you combine it with the prior slide, it should be more troubling because it suggests CEOs who are already inclined to use corporate money, possibly using the jet for political purposes for their own advancement, but also just more generally as a marker of that. So basic point here is agency cost of a familiar kind showing up in the political area in a way that the Supreme Court doesn't seem to have adequately dealt with at all. Now, what about more broadly? This is a much bigger problem once you look beyond the immediate corporation itself and think about the way the First Amendment is being used by companies. So these are all cases since 2011. They're either Supreme Court or Circuit Court. They're all cases in which the First Amendment was successfully used to strike down either disclosure regulation or controls on what could and couldn't be said in a given context by companies. And I don't have time to go through it all, but I will take, as a takeaway for you, I will suggest that this is an unworkable, unsustainable system. In all of these cases, a business is using the First Amendment to go after what is often a long-settled regulatory body to unsettle it to get a business advantage over other businesses. It's just pure rent-seeking in a traditional economic context. It's wasteful because the litigators who do this are very well paid, and worse, I'll come to in a second, it has distorting effects on investment. If you think Lochner 2.0 is an exaggeration, I don't get that. I didn't make that up. That comes from Kennedy himself, who some of you may have seen recently, where he gets that that's what they're doing, right? He quotes Holmes's famous critique of Lochnerism and then says, yeah, but still we get the First Amendment, right? Now, the First Amendment, however, doesn't say what I think Kennedy seems to think it says. Certainly doesn't say it by its plain terms. So when he pretends here that he is forced to a Lochnerism 2.0 by virtue of the text of the First Amendment, he is kidding you and probably kidding himself. So here are some examples of the industries, to go back to these cases, just so if you're going into practice, here's what you get to deal with. Privacy laws, drug marketing laws, food marketing laws, price competition, auto insurance, conflict mineral operations in Africa. What am I missing? Pretty much food safety, drug safety as well as promotion. All of them have been attacked. So why is this bad? Because, you know, obviously it unsettles old policy and prevents investment formed on the basis of clear expectations about what the rules of the game are. It suppresses resolution of very difficult policy trade-offs, because now if you know that you've got another round after the negotiation through the agency in which somebody's going to go after the settlement through the court system, that's going to change the game. It's going to make it a lot harder to get the initial resolution. the SEC increasingly is finding it harder to pass simple rules because they're worried about getting attacked under the First Amendment. And somewhat counterintuitively, until I started looking at these cases, I wouldn't have predicted this. The way First Amendment law works, it practically has the effect of inviting greater restrictions on liberty to justify the lesser. So just to touch on those one more time. On the first one, I was at a food and drug law conference in Washington the other day, and I heard somebody who works for one of the big drug companies say, we don't know what the rules are anymore about off-label promotion. For those of you who follow the drug world, drug companies get an FDA-approved use for a drug, and then they can market for that. And then because the FDA doesn't directly regulate doctors, doctors are allowed to prescribe for other uses the same drug if they, in their medical wisdom, think it's safe. So the drug companies know that, and as alternative uses are developed, even ones that haven't been tested yet, they want to promote these alternative off-label uses. The FDA has strongly restricted traditionally the ability of the pharma companies to do that, but of course that's speech restriction, now directly attacked in Coronia and Amarin more recently. And essentially the pharmaceutical companies don't now know whether they're fully licensed to go out and promote whatever they want or not. They're not sure. Maybe it depends on the circuit. Maybe it depends exactly on what judge you get. And they hate this even while they like it. They like it in a particular narrow context, but they hate the idea of becoming the dietary supplement industry, which, you know, I hope nobody in the room buys homeopathic remedies because they're a crock. Real pharmaceuticals actually do lots of good. They could also do lots of harm, which is why we regulate them, but they really do a lot of good. If you buy, I don't know, did you hear the thing about CVS? They were caught marketing a homeopathic constipation remedy that had 40% alcohol, and teenagers had figured this out. So they were going in and buying lots of this remedy. They had a lot of constipation in the community, I guess. And there's a good way to, I mean, alcohol will do it, I guess, if you drink enough of it. That's the dietary supplement industry. And most people who are all self-aware realize that most of the time you're being conned in that world. I, again, hope I'm not offending anyone, but most dietary supplements are nonsense. The pharma industry didn't take off and get profitable until the FDA regime was put into place after the thalidomide disaster. Their profits depend upon consumers and doctors believing what they do is actually supported by science. And so they don't like the idea of having the entire consumer world start to doubt whether or not their drugs can be safely used. And don't kid yourself, the doctors, while on average, I'm sure, are very nice people. I know some nice doctors. They're very corruptible. And there are business plans right now being developed to corrupt as many doctors as possible in the way that I've just described. So that's just GMO labeling at issue now in a lot of states. Nobody knows whether those are constitutional or not. Therefore, the entire organic food business and the people who compete with it don't know what the rules of the game are for the next 10 years. Flip down here. Obviously, Congress can't undo in a direct way any kind of constitutional decision. That's obvious. Maybe less obvious, but shouldn't be that hard to get there too. The agencies who are often told by courts, your rules don't fit your purpose tightly enough under our First Amendment analysis, you should go back and get the whole statutory framework changed. That whole off-labeling idea of not regulating doctors and regulating them, that doesn't fit the First Amendment, so just get Congress to redo it. That's just as hard, if not as impossible, as changing the Constitution. The FDA is practically politically incapable of getting Congress to rewrite the entire drug regime in a quick fashion. And if they did, I would worry actually about what would come out the other side of that long process. So that's a second problem. The third problem is, it's clear that Congress has authority under other parts of the Constitution to ban drugs. So do we want that as an outcome here, which is where we were likely to head, right? The likely result then of freeing up off-label promotion is to result in more banning of drugs. And that seems like a fairly perverse result for somebody interested in pursuing freedom. Okay, so that's, now for business, just to restate what I've already said in a slightly more abstract way, the result of all this is bad because it encourages investment in litigators, and again, no offense to any litigators in the room, but you're not where I want businesses to be putting their focus. right? I want them to be thinking about innovation. I want them to be investing in R&D. I don't want them worrying about the uncertainty of the regulatory regime that this kind of litigation strategy will create. And given the scarcity of time, most businesses can only, if they're large, and most of these industries now are full of quite large companies, they really can't run a strategy that's very complicated. They have to be pretty simple and focused in order to communicate with 157,000 employees at Pfizer, for example. And so if you start adding into that mix a whole bunch of other things like litigation strategy, and you have to contingency in this game theoretic thing, it's just not going to work. They're going to end up with fewer good strategies as a result of being crowded out just in the minds of the people running these companies. It also is going to distort careers in business and reward people for things that are not really adding value to society. And for society, it's pretty straightforward that more rent-seeking of this kind is going to produce more opportunities for corruption. More corruption lowers investment, less return, less growth. And so to me, it all seems pretty straightforward. Now, what about this idea that Powell has that we can fix all this just by relying on shareholders to do all the work? They can control these bad corporate actors. Well, to state one obvious point, some of the prior slides, the shareholders' interests are aligned with the corporate manager's interest if in the short run it produces more profit. So there isn't going to be a tight alignment between shareholder interest and societal. But even if you thought shareholders might rein in some of the misuse of corporate money for political purposes, here's a problem. So this is an amicus brief that I've helped put together. We're about to file probably this week. 18 corporate law professors from all the top schools, not that that matters. We all agree that Powell's wrong. It's hard to find a corporate law professor who would disagree with the following statements. The board decides, not the shareholders. Shareholders have no power to instruct the board on their own, unlike the UK where they do. The derivative lawsuit mechanism, as already alluded, is basically going to be overridden by the business judgment rule unless the CEO is personally getting money directly out of the individual activity, and political activity doesn't involve that. It's money flowing out to someone else. So you need a radical revision of Delaware case law to change that. What about, Powell actually has a statement that's just flat wrong. You should know this from corporate law, that shareholders have the right to withdraw their money. No, that's true in the partnership. It's not true in the corporate form. That is what distinguishes the corporate form in part from the partnership. What about the right to sell? Well, for 12,000 companies with 10 million or more in assets and 100 more shareholders out there, there is no market. They're private. They can't sell. These are family companies that have grown larger over time. Their ownership is dispersed enough, so there are real conflicts of interest, but there is no market for them. What about public companies? Well, you can't sell to discipline political activity if you don't know that it's happening. And currently, there are no disclosure obligations at the SEC, at the FEC, through Congress, to find out exactly what the companies are doing. A few companies, about 150 out of the 4,000, have now voluntarily committed, often under shareholder pressure, to making disclosure. But even those companies, all but a very small number, only make incomplete disclosure. They don't make disclosure about donations to the Chamber of Commerce, which are often earmarked for particular political purposes. So disclosure, you just don't have it. And so even though you have a liquid market to sell in, you're not going to know to do it. Moreover, even if you found out about something you didn't like, it's too late. It's already happened under your name as a shareholder. And if you're interested in sort of moral theory, which the court seems to occasionally be in this area, in the First Amendment area, the company will have already spoken on your behalf in ways that almost guaranteed a majority of the shareholders would have very strong views one way or the other about. Certainly not together. And what about voting? Well, any serious study of proxy contests will tell you that this is not a meaningful option for the vast majority of shareholders. There are a very small number, even run by the shareholder activists, who've increased their activity over the last 10 years, less than 100 over a 10-year period for major companies. Again, 4,000 companies, 10 years, that's 40,000, whatever. 100 over 40,000 is a very small fraction. So the voting power is not a meaningful discipline on management either. So that's a quick review of corporate law. To make matters even worse, if you think about the First Amendment as basically being ultimately about expression, most stock is now owned by institutions, not by individuals. That institutional ownership is not even just simply an institution. It looks like this, where the nominal shareholders are over here. The actual you in the future, typical investor over here, is this. You own through a 401k that the employer sets up and limits your ability to choose, forcing you to invest in sensible options, hopefully like a Vanguard fund. But that Vanguard fund is going to own Chevron whether you like it or not. And you have no ability to do anything about that down the chain. The 401k doesn't give you the choice. The Vanguard fund doesn't give you the choice. And even Vanguard itself has bound itself to maintaining an index ownership. And so it couldn't even sell, even if it knew that every single one of its clients wanted it to. So the structure of ownership is such that shareholders can't do much meaningfully. Now, you might say, well, just don't buy stock. And that's just silly. You can't not buy stock, okay? You have to buy stock if you want to retire. None of you are counting on Social Security to help you. We all are about, we're all fairly sure something bad will go wrong with it before we're all retired. Not exactly sure what, but somehow something will go bad. So you're going to have to invest, and you're going to have to invest in equity, because if you invest in government bonds and if you invested in corporate bonds, the line would be a little higher, but not much. So basically, most of the value of an investment you make at the age of 30 would be wiped out if you don't invest in stock. Likewise, you could try staying out of those 401ks and keeping the flexibility. And while the damage is not so bad, it's still pretty bad. It's basically like a tax of 30% over the course of a typical investment. And this is actually understating it, because this is just one investment. You're going to make a series of them over your life. So you're basically forced, whether you like it or not, through a combination of tax policy and financial reality, to invest your money in companies who are going to be out there speaking under current law on your behalf, under the First Amendment, attacking regulations that you probably actually benefit from, at least in a lot of circumstances. Okay, so that's why all this is bad. Have I at least gotten you to think it's a little bit bad? So now let's talk about what we might do about it. Could we fix it through securities law? Well, no, because you're going to ultimately run into a constitutional challenge to any fix that the SEC or Congress or the Delaware legislature might put into place. Because what's the first thing you want to do? Disclosure? Well, that can violate the First Amendment, because it forces a company to speak. And you look at the tobacco labeling case, where the premise of the tobacco labeling case decision was that because the images on the packages were disturbing, that wasn't rational, truthful speech. And since it wasn't rational, truthful speech, you can't make the company say that we're going to destroy your lungs and make them look really black, because that's not really truthful, factual, under the case law. That's just something else. That's manipulation. That's bad and evil by the government manipulating you. And so you can be sure the same kind of attack would be brought about disclosure of political activity. Why? Because the political activity would just be emotional, inflaming. You can hear the Eugene Scalia brief being written as I talk. So in order to do corporate law reform, you need con law reform. You need the court to at least rein in the circuit courts in the way they're applying the First Amendment, and preferably do something more. What about constitutional amendments? Well, they're hard. Convention, they're hard. So that leaves us with the current Constitution, which actually doesn't say what the court seems to think it says. So here's this. Here's my proposal. It's a little bit wordy, but just focus on the right side for the legal part of it. It's pretty straightforward and simple. We should go back to the world that we had in 1977, within my lifetime. Your lifetime? I don't know. How many people were born after 1977? That's depressing. OK. Well, ever so slightly before your lifetime is where we want to go back. And basically go back to a world in which the court looks through organizations to the individuals, has a realistic sense of what they're coming to this organization for, takes that sense and relates it to the purpose of the constitutional provision in question, and asks, is the constitutional interest here being advanced by treating the corporation as if it were a person for this purpose, and not making the simple leap, the logical leap. The leap that says things like, it's bad to discriminate against a corporate speaker because of their corporate identity. The court, on the one hand, denies that it's making the simple leap, person, corporation, rights. But in fact, when it says discrimination based on the corporate identity is objectionable in and of itself, which it said many times, it is making that leap. It shouldn't do that. It should think about who is that speaking on behalf of the corporation, who owns the corporation, are their interests, in fact, aligned with the investors? And is the speech in question a particularly valuable form of speech for the relevant people at the table? And for commercial speech, more broadly, efforts to sell things, just simply go back to rational basis, which is what we had until 1978, 76 for that one. So go back to 1975. Now, just to play it out a little bit why I think this is in fact constitutional, well, I've already given you the precedent. So we had 170 years where this was the law. So precedent, I win. That one's easy. In addition, the court has developed, in Casey and subsequent cases, a whole set of doctrines about when to reverse precedent. It didn't follow any of those when it reversed precedent in Citizens United. But if you did follow those, one of the tests is unworkability. And I submit to you that diagram I showed you with Central Hudson going straight up over time, that's an unworkable system. That's a perfect basis for the court to say, you know, we've thought about this whole commercial speech, constitutional speech, and corporations thing, and it's not working out. Text is totally unclear. I'm happy to talk about that in the colloquy, but the basic point is corporation doesn't appear, business doesn't appear, and most of the bases for the speech regulation were implicit in common law prior to the founding. So that's why I don't think that also goes to original intent. And we have the roughly contemporaneous evidence from Marshall himself. Structure, if you think about the best purpose you could put on, say, Virginia pharmacy, it's consumers in that case were being prevented from getting price information. And we want robust competition. And I'm all in favor of that. I actually think the court's goal in that case was good. And had I been a legislator, I would have voted in favor of a change to the ban on price competition in drugs in Virginia. But in order to trade off the advantages of competition against what are the advantages of having some restriction on disclosure of prices, well, lawyers for a long time were banned for that reason. Why? Because aggressive price competition, it was thought in a professional context where it's very difficult to evaluate the services of lawyers, will lead to ever lower prices and ever lower quality, and consumers will have no ability to judge for themselves as a practical matter. Now, you may not buy that, but I think it's at least plausible in some contexts. And certainly once you flip to drugs, where I'll submit to you, like I, have no ability to decide whether the blue pill or the yellow pill or the purple pill are better, free market competition doesn't work quite the same way. We need some kind of screen, some kind of gatekeeper to help us assess that, and that is the point of the disclosure regulation. We either ban it, or we have somebody helping us make the decision, and in order to make us help the decision, you have to restrict or channel or control what's said by whom and when. Okay, so that's on structure. And the bottom line here is courts just can't get this information. This is not a constitutional role. This is a role that Lochnerism tried to give the courts, and they failed miserably. Morality, corporations have no souls to damn, one exception. Nonprofits, small companies. I could imagine myself in Hobby Lobby possibly agreeing with Alito for once, because there you had a family company and all the shareholders agreed. You still have employees, and the court didn't really take them into account, so I think it's more complicated than the court really engaged. But at least as a starting point, this is a reasonable exception. Hard to know about what the people think about all this. They hate Citizens United. They don't know anything about commercial speech, even though it's actually more important. And probably if you explained it to them, they wouldn't like that, but who knows. And consequences. So those are the various things the court has typically taken up when it's done constitutional law. And so that's my analysis. I will stop there. Questions? And there's mics that are going to be brought around for anybody who has one, because we're being taped. There are all kinds of worries you might have about my idea. Yeah, here.
Thanks so much for the talk. Is there a good way to distinguish between political speech and then the drug company promotional speech or the advertising speech, which is, at its heart, commercial? Is there a good way of doing that? Is it worthwhile to do that, or should we just chuck the whole thing out?
Yeah, no, it's a great question. It is a problem for me because I do want to maintain the First Amendment protection of political speech, even as I'm demoting commercial speech. But it's no more of a problem for me than it is for the courts already, because the courts already purport to separate off commercial speech and give it a different treatment than from political speech. So I'm not going to be making anything worse by lowering the amount of deference we give to commercial speech. We still have the problem of differentiating. And this is an ongoing area of dispute. So the traditional test is if it proposes nothing more than a sale, it's commercial. And if they're doing something more, then maybe it's political, depending on what the more is. So the hard question would be the pharma company not actually saying, buy this drug because it'll get us money. But here's a scientific study about this drug. That's all we're saying. Here's the study. Now, it's obviously being done in order to sell drugs. It has a totally different content and a different author than the company. There's still plenty of room for abuse. They could hand you the one study and not give you the other study. And so I personally would tend to err on the side of the obvious, which is, if it's political overtly as its primary focus, then you give it more deference. But recognize, too, I'm also proposing to deconstitutionalize the corporation as such. And so if even political speech is going to be protected, you have to figure out who is speaking. Right? And it's not the corporation. If it's the CEO of a publicly held company, sorry, I don't give that any deference because the CEO is not the owner of the company. It's the shareholders who are, and the shareholders haven't approved the political speech. Other questions? Yep.
Hi, sure. I'm Thea. I'm a 3L. So you mentioned before the idea of coerced speech, and I was just wondering if there's any ability to make an argument on the opposite side of that equation, and to say that, let's say you're a shareholder in some sort of a closed corporation or some corporation where you don't have an ability to sell your shares. Mm-hmm. Now you have the corporation out there politically, yes, exactly, speaking for you, and no ability to do anything to get yourself out of that situation. Is there an argument for coerced speech there?
So, yes. Now, as a matter, though, of constitutional doctrine, what's the problem? Even if it is clearly coerced. State action, right? So now, presumably in your hypo, it's a private company. Now, you could make two arguments. I still think these are a stretch, but you could argue that since it's chartered by Delaware, that's a form of state action in creating the entity, and therefore somehow that's, I think, maybe a better. The reason that's not a strong argument is because since the Jacksonian era, anybody can walk in and charter a corporation at any time. It's not really like the government is making a discretionary decision to do that. A better argument, I think, is the tax policy point. The 401k effectively channels and forces practically most people into certain kinds of investments. And that is government choice, tax policy. That's not typically been the basis for state action, but courts have made up other law, so why not make up that law? That would be the problem. I think in the end, for me, it's the very fact that there is no way for the individual shareholder to vindicate their interest under the Constitution that I would rather get the corporation out of the First Amendment and go back to simply having legislative resolution of the disputes. And there'll still be disputes. There's still going to be companies that are going to have a good case for why they should be involved in politics. Right? Boeing, their whole business model depends upon the Defense Department. So if you get them out of politics, that's not so good for Boeing, right?
You mentioned that Kennedy might be kidding himself in his interpretation of Lochner.
Yeah.
Are there any hints as to why he might have interpreted it that way?
Well, I think he believes Powell. I think he believes that shareholders are capable of controlling companies. And why does he believe that? Because he had corporate law in law school. And the Supreme Court almost never gets corporate law cases. So they don't learn any more over time. They forget things over time. You now know more corporate law than the Supreme Court. I'm sort of slightly overstating, but not really. You guys have had corporate law presumably, or are taking it now, or soon will. You actually have. You've been reading. You read all those cases. You read all of that. I hope you did at least. And you're going to have a bar exam on it anyway. So you've got a bunch of corporate law in your head. They last did that a long time ago, and they only episodically do it in response to maybe, even if you count securities law cases, they get one case a term. So the reason I think Kennedy believes what he believes about it is that he thinks shareholders are perfectly capable of controlling companies, in which case my rent-seeking argument, at least on that prong, falls away. So I don't know if that helps. Yeah.
So I wanted to ask in terms of mode of changing constitutional law, and the story that's often told is around the Powell memoranda and the chamber getting into litigation practice and NFIB and a number of other kind of organized business interests that very consciously work to change constitutional law. You alluded to the fact that not all businesses have these interests, that deregulation serves some businesses better than others, the example of turning kind of drug companies into homeopathic remedy companies would not be good. So I'm wondering, is there any prospect for some companies to push back against this? And are there briefs being filed? Is that an argument that's being made out in the world? Or is it more kind of consumer groups and law professors and the traditional progressive coalition that would be the pushback here?
Well, so it's a great question. There is an organization, I'm blanking on the name, Council for Economic Development, I think it's called, which is basically a business group. But they're very active in fighting on corporate involvement in judicial elections, because it's much easier to see the commonality of business interests in getting politics out of judging directly, right? State elections in particular. When you go to the next level and ask about electoral politics, most companies view overt involvement in any way, including lobbying to get other companies out of it, as risking political involvement that they don't want. That's why they give money to the chamber rather than giving money directly. Chevron is a rare example of a company who just gives money to super PACs. That's because they know everyone hates them. So they're not going to get anyone to hate them anymore by doing it openly. But any kind of retail company is going to be very cautious, I think, about doing that. Now, having said that, very recently, there was a poll actually just circulated recently of directors of S&P 500 companies. And for the first time, more than half now endorse the idea of at least disclosure rules being imposed on political activity of public companies. That's new, and I think it's partly for the reason that you're asking about. They're recognizing that they're kind of being increasingly asked in private to give increasingly large amounts of money in ways that don't clearly benefit the company, but they're sort of being extorted about it. And so they'd rather have it be all transparent. Then they have the ability to say, no, I can't give to you because I'll have to disclose it and that'll be a big problem, and so I just can't. So that's the beginnings, I think, of a movement here. But most corporate directors, as a first pass, don't naturally think of regulation as their friend. They have to be educated to see that, in fact, in some market communities, market context, that is true. And so I think it's a long, persuasive game for many of them. Laura? Yep.
So I was wondering if you've looked at any data on if increases in regulation or any changes in the amount of regulations that corporations have come under, if that's impact at all the amount that corporations want to get engaged in political campaigns, or if that's had any impact at all.
Yeah, I mean, so to the best of my knowledge, measuring the amount of regulation in aggregate is a really hard and difficult and so far not successfully done task. The best thing I've seen are page counts, which is just on some level silly because you could have one industry, Dodd-Frank, generating a gigantic amount of pages, and then if you took that as a measure of overall regulation, it would be incredibly misleading. Not so much for banking, but it would be for everybody else. Even if you do it by industry, you get, if you think about it, more pages when agencies pass safe harbors. So longer actually is less regulation. It's not a very good way to measure things. Now, if you take a big step back, most of the rules that have been attacked in the cases I had up on the PowerPoint a little while ago are rules that have been in place for 30 years. So these are not new regulations that have been imposed that the business community is now resisting. These are old rules which either somebody seeking a disruptive business strategy is trying to strike down to be able to do something, which might be good, but it also might be bad, depending on the exact business plan involved. Or it's incumbents who've got some new threat or strategy they have in mind that are trying to go after a regulation that inhibits them. So this is a long-winded way of saying my overall impression is that the litigation patterns don't seem to be targeting new regulation. And if you think about the timing also, coincident with the increase in First Amendment cases is actually a decrease in regulation. So the deregulatory wave, where you go through industry after industry in the 70s and 80s and 90s that went through a massive amount of deregulation, even as the rise in First Amendment cases was taking off. So it would be 30% of all studies conclude that we need more research. So we need more research. It would be a first important step to figure out a good way to measure the amount of regulation. And that's hard to do. Okay. Yep.
Yeah, I was wondering if, in your estimation, you sort of alluded to this earlier, if sort of people are wrong to focus more on Citizens United rather than commercial speech, like sort of focusing on a symptom rather than the root issue. You mentioned how a few companies spend directly out of corporate treasuries to super PACs. It's usually wealthy individuals. If like sort of the root problem is protecting this commercial speech, and Citizens United is just kind of a symptom of that, like greater solicitude towards corporate First Amendment rights.
Mm-hmm. As I've thought as longer and longer about the overall problem, I've increasingly come to that view. Having said that, what initially got me involved was Citizens United, in part because it just seems to follow, for me at least, that if the Supreme Court believes several false things about corporations and then predicates decisions on it, that's a bad thing. So regardless of the particulars of Citizens United. I should also say that if I'd been on the court, and thankfully that's not a risk, thankfully for everyone, the Citizens United nonprofit would have won. I would have let them broadcast their video because they were formed for the purpose of expression. That's exactly the kind of company that has an expressive interest in speech of the very nature that was being prevented in the case. Now, you still have, so having said that, there are occasionally glimmers when some staff person messes up and we get documents that are usually kept private, suggesting that corporations are much more active in electoral politics than is evident from the public data. So the Republican Governors Association had an event at which corporations paid upwards of $350,000, $500,000 just to be at that event. About 40 of them were public companies. This all got released, even though it normally is not disclosed by accident. It shows up on the web. They immediately clawed it back, but somebody had archived it, so now it's in the public domain. So that's just like one event that suggests that, in fact, companies are far more active than we know. The reason that's not disclosed is because that's not a donation to a candidate. That's participation in a 501c4 or 501c6, which does not have to disclose their membership. So that's the reason I say that is, therefore, I still think corporate political activity is a problem, even if the bigger problem is commercial speech. Yeah. All right. So have I thoroughly depressed everyone? Trevor was pretty depressing too, keep thinking about these problems, and hopefully, if anybody of you wants to get involved in some efforts, there is one little tantalizing glimmer of hope, I would say, which is that Delaware law does allow shareholders to man books and records. 220 is the statutory section. Now, most individual shareholders can't use this route to get information, but there are some pension funds out there who are thinking about trying to use it more actively to get information about political activity. And it's at least theoretically an avenue that could work out over time. And so if anybody has any interest in working on cases like that, I know some people I can put you in touch with. That would be happy to help you. So that's all. Thank you.